My name is Jahnavi Anand and I'm pursuing my LLM from Christ University, and I'm also interning under the guidance of Jeevan Prakash sir. Today I will be talking about the legitimacy of a child born out of a live-in relationship. So what comes into your mind when I say about a de facto marriage or a live-in relationship? We all are aware that de facto marriage or live-in relationship has always been considered as a taboo in India. But do you actually know that the Supreme Court, in one of its observations, stated that the law nowhere prohibits live-in relationship or premarital sex? In fact, it stated that living together is a right to live, which is covered under the Article 21 of the Constitution of India. So what is exactly a de facto marriage or a live-in relationship? De facto marriage or live-in relationship is a cohabitation or an agreement where two people decide to live together for a long period in an emotionally and sexually intimate relationship. This term is actually used for people who are not married. So now the question arises that if a child is born out of a de facto marriage, will that child be a legitimate child or an illegitimate child? So the Supreme Court, in one of its cases, stated that if a child is born out of a live-in relationship, that child will be considered as a legitimate child. So now, will that child have the right to inheritance? The Supreme Court, in one of its cases, stated that no, the child born out of a live-in relationship will have no right to inheritance in the Hindu co-parental property. But that child will have the right to property in the parents' self-acquired property. So lastly, I would like to conclude that live-in relationships are becoming very common in India. The law does not prescribe how we should live. It is the ethics and social norms which explains the essence of living in a welfare society. Thank you so much.